Recently, an increasing number of cases have come before the courts where the decision whether or not to permit or refuse medical treatment has led to the making of anxious decisions. The complications we have faced have attracted the public interest, and the difficulty lies with the outwardly irreconcilable conflicts of ethical and moral values, and it is this court's job to apply those legal principles. The law for male circumcision can be founded in the case of the Queen and Brown, where ritual circumcision is considered to be lawful. In the case of Queen and J 2000, where for circumcision to be ordered, there would have to be clear benefits to J, which would demonstrate that circumcision was in the interest, notwithstanding the risks. The law for female circumcision is governed by the Prohibition of Female Circumcision Act, as well as the Female Genital Mutilation Act, which extended penalties for carrying out female circumcision from 5 years to 15 years. In short, the mother has circumcised both her son and daughter, to which the father did not consent. The questions we will address was the circumcision of the boy lawful and in his best interests, and secondly, was the circumcision of the girl lawful and in her best interests.
My lord, today I will be speaking in favour of female circumcision. My submission will focus on 4 aspects: the idea of autonomy, consent, consequences, and finally, cultural relativism. Concerning autonomy, scholar Christine Mason has examined that an adult female does not have the right to have cosmetic surgery for herself, but has the right legally to alter the penis of her son. Surely, this is unfairness in the law and must be addressed. With consent, Sheldon and Wilkinson have argued that general social pressure to conform are not genuinely consensual.
My lord, point of information.
Rejected.
Therefore, the likes of labia trimming, breast enlargement are also not consensual, but in the present law they are. With consequences, today's society is all about harm reduction, but surely by driving female circumcision underground, this is not going to reduce the harm. By legalising female circumcision, the hygienic conditions will be improved. There'll be medical procedures put in place to prevent these, and there's also the skill of the level of the cutter will be improved as well. Shell Duncan, Morelli and Obiero have said that the complications are linked to the more serious forms of female circumcision, therefore a blanket ban should not be done. With cultural relativism, it's all about human rights versus cultural rights. Dr. Amadou have said that female sisters insist on denying us this critical aspect of becoming a woman in accordance with our unique and powerful cultural heritage. Surely denying people of their culture is wrong. Therefore, the appeal should be dismissed.
My lord, today I'll be speaking against the practice of female circumcision. My argument will be split into 4 sections, beginning with autonomy. To begin with autonomy, my lord, I'll refer to the idea of mutilation and beautification. The main principle behind this idea is that women who undergo practices of female circumcision are doing so to attain and adhere aesthetic ideas of beauty, femininity, and womanhood. They are also bowing to societal and patriarchal oppression. For example, in certain communities, men will not marry women unless they've undergone circumcision. This is because it proves they're a virgin and therefore they can be married. If women are forced to meet such requirements, it is likely that they will be more inclined to undergo such procedures. Legal response to genital cutting outlines that the desire to comply with the cultural pressure is not an expression of autonomy, but a symptom of social oppression. Black and DeBell further argue that it is an exercise in male supremacy and oppression of women. In regard to consent, the main issues regard the age of consent and informed decision-making. Sheldon and Wilkinson outline the problems of education and access to information necessary to make a valid decision mitigate the woman's consent. When regarding consequences, we must outline that female circumcision has no health benefits to women. It actually has psychological and physical injury. Last issue, female circumcision progression parallels, outlines that female circumcision is linked with primarily infertility, poor obstetric outcomes, and neonatal conditions. After circumcision, 50% of women need a secondary operation because of complications, and generally need another again due to sexual intercourse and delivery. Findings by Bibbings outline the conditions in which female circumcision are held. Sanitary conditions and medically qualified individuals can perform female circumcision, however, local barbers can too. Based on these points and the range of practices encompassed under female circumcision, we believe that the law should remain as it is.
We will now hear the submission from Mr. Patel QC against male circumcision.
My Lord, my submission today will focus on three aspects. Male circumcision is unregulated, there is the issue of consent, and finally the gap in the statutory provisions. At the heart of this issue is the gap in the law. Academic scholars Fox and Thompson have provided a partial explanation as to why the law has skirted around this issue. In the case of the Queen versus Brown, Lord Templeman categorised ritual circumcision as a form of consensual activity that has been likened to that of boxing. This suggests that ritual circumcision is a part of everyday life and does not take into account the irreversible harm it causes to individuals. Carol Smart looks at the meaning of the word harm in a historical context and looks as though it has provided less protection to men. She states that harm is seen in a historical context relating to male masculinity and being able to identify with their father through a process of manhood. The issue of consent has been raised in reference to the case of Jay and found that there still needed to be joint parental consent for the operation. However, as highlighted by Howard Gilbert, it still remains lawful to perform a ritual circumcision where there is joint parental consent. Justice Wall's judgment fails to take into account the right of the child to physical integrity and protection afforded to him under the ECHR. Thus, there is no balancing of the rights of the male infant against the rights of the parent to manifest their religious beliefs. The default position adopted by that of the state as a result of the judgment is that the male infant has no rights that need to be protected in such a situation. Finally, Karen Dyer's article highlighted the unregulated practices of these operations. Many are carried out without any official training or assistance. This has led to a number of deaths which had not been fraud by the prosecution. In 2007, 2 male infants died after an excessive bleeding operation. The coroner stated that there had been insufficient post-operative care which led to their death. What should be required by Parliament is a minimum level of statutory protection. The operation should only be performed by recognised and qualified doctors. They should prohibit male circumcision unless it is medically necessary. And finally, ritual circumcision is only to be carried out where a male gives his lawful consent.
We will now hear the submission of Mr. Batak QC in favour of male circumcision.
My Lord, throughout this appeal, I will be giving justification for my firm support of male circumcision and its benefits. Firstly, clinical trials conducted in sub-Saharan Africa suggest that circumcision inhibits the spread of HIV and AIDS. Academic scholars Fox and Thompson have asserted that circumcision, and I quote, serves a partial protective effect against HIV infection for circumcised men. A controlled trial in South Africa in 2005 found that over a 24-month period, circumcision reduced the risk for men acquiring HIV by over 50%. Such results were duplicated in Kenya and Uganda. Furthermore, the complication rate of male circumcision is between a mere 0.2 and 0.6%. Moving on, religions such as Judaism and Islam require males to be circumcised at a young age. A ban on infant circumcision therefore denies religious freedoms to Jewish and Muslim parents. This would contravene Article 9 of the ECHR. Opponents of male circumcision argue that the procedure is performed with parental consent but not with the infant's assent. However, parents provide consent for other procedures such as immunisation, including hepatitis B vaccination, acting in the best interest of their children. Banning infant male circumcision would therefore deprive parents of the right to act on behalf of their children's health. Lastly, some who oppose male circumcision cite anecdotal reports that male circumcision can cause sexual dysfunction. Male circumcision trials have found there to be no significant differences in male sexual satisfaction before and after the procedure. My Lord, it is clear that male circumcision is clearly beneficial for the health of infant males, is crucial in upholding religious freedom, and has no substantial implications for sexual gratification. For these reasons, the appeal should be dismissed.
Thank you for your submissions. Based on the arguments raised by Ms. Wakayamba QC on the grounds of the autonomy of the individual, consent, consequences, and the conditions, I deem the proposed operation for female circumcision to therefore be unlawful. On the second question addressed in the court in regards to male circumcision, upon Mr. Recorder Batak QC submission, based on sexual activity, religious cultural freedom, medical justification, and previous precedent, I would therefore deem the operation lawful. Appeal dismissed.